Here now with more. Constitutional lawyer, scholar, Fox News contributor, Jonathan Turley. Jonathan, let's first start, before we get into the warrant itself and the history of the FBI and the DOJ with Donald Trump, I want to ask you about the president's claim that this has all been declassified anyway. Your thoughts on that's a big development that John Solomon brought up tonight.
Well, it's a major question that has to be addressed if there's going to be any serious discussion of a criminal charge. The inclusion of the Espionage Act in the warrant was notable because that's the same basis upon which Hillary Clinton was investigated for her own controversy. Now, what was notable about that is that the Justice Department at the time said that they've never had faith in a gross negligence basis for using that statute. And it was on that basis that they said that they had declined a charge in the case. So the question here is whether the FBI believes it has not gross negligence, but an intentional act by the former president. And that goes to this defense. Now, there's a lot that we have to learn. You know, if he was declassifying material, as we've been told, in the final days of his administration, there is obviously a ripe opportunity for mistakes to be made by him, by his staff, by others. Usually when you declassify a document, the markings are actually scratched out. There's a line drawn through them. So there's physical changes on the face of these documents. Whether that actually occurred or whether actual declassification occurred may be at the heart of this controversy. But that's a very muddled record because the president has inherent declassification authority. There are regulations, but we've never really had to litigate that question as to what is necessary for declassification to be viewed as a legal finality or certainty, but also whether the president could have had a good faith reason to believe that there was declassification. All of that we're going to have to work out if the Department of Justice goes forward.
Then we have the issue of the timeline. The National Archives and Record Administration, their letter of thanks for all the cooperation of the Trump team at Mar-a-Lago from February of this year. And then I think a very important date is June 3rd, because you had the FBI and DOJ officials at Mar-a-Lago viewing the boxes. They had access to them that day, right there. Apparently later the president came and met with them. They asked that a padlock be put on the storage room where they were being held. That request was complied with. And I've had multiple people tell me that they heard the president say, "You're welcome back anytime. If you need to get anything in the storage, feel free. We'll accommodate any request." So when you look at that timeline, that doesn't sound like somebody that's trying to hide something, does it?
Well, that's the reason why from the very beginning, many of us said we need that affidavit. Because of this time period after that June meeting, if they were discussing a lock on a door and improving that security, the question is, did they actually ask for material to be moved to a secure location at that time? Were they refused? What was the basis for their asking for that added security? We don't know because we don't have that affidavit. What I can tell you is that TSSCI material is highly classified. I've worked with it in the past. When you work with it, you're not even allowed to bring your phone into a SCIF. Security officers are very reluctant to make any type of accommodation. So if they believed that there was TSSCI material in June, it's rather bizarre that they would wait this whole time before they made a move of this kind.
Jonathan, it's a mystery. You're right. We'll learn a lot more with the affidavit and a lot more in the days to come. Appreciate you being with us. Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.